Start with the minutes from last month's meeting. Does anybody have any corrections, revisions? Motion to approve?
None here.
No.
I'll make a motion we accept it. Minutes.
Second. Moved and seconded. All in favor? Aye. Motion carries. Staff, do we have any revisions to today's agenda?
13 CE 3948 4504 Bethel Creek is being pulled from the agenda. He has applied for the permit and paid the fine, so we're going to give him time to come into compliance.
Which one was it?
That is C1D. Second court. Okay, I'll move we accept the agenda as modified.
Did you have something you wanted to pull, Tom? I thought there was 2 cases that you wanted to pull.
There were.
Oh, good.
I thought you had pulled them. I haven't had the new agenda. They are case, 13-CE-3927, or E on your agenda, and case number 13-CE-3866, or C.
Okay.
C-3866.
C, D, and E. Thank you. Okay, now I'll move that we accept the agenda as modified. Second? Anyone?
Second.
All in favor? Aye.
Aye.
Motion carries. In light of the potentially long hearing we're going to have on the first item of the agenda, is there anyone here that's not here for the case concerning John and Tracy Carroll? Okay.
Okay.
Then you're all in the right place.
Get on with the show.
Then we'll start with case 13-CE-3954, John M. and Tracy M. Carroll.
You ready?
Everybody that is planning on testifying, please stand up and be sworn in.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
This is for citation number 13-CE-3954, currently being appealed. The violator, John and Tracy Carroll, were cited for a violation of transient or short-term rentals at 530 Camellia Lane, as provided in the backup materials. Service of the citation was provided by certified mail and is provided on file with the city clerk's office. A request for an appeal on the citation has been received, so hearing to contest the citation has been requested. The violation has been corrected as of August 14th, 2013, and the civil penalty assessed on the citation has not been paid. Enforcement costs of $458.81 are requested by the city. An affidavit of these itemized costs has been filed with the board clerk, and we request the backup material be made part of the record. We request the board deny the appeal and find a violation of the code, along with enhanced civil penalties of $300 and the cost of enforcement of $458.81. Do you want me to go into
Please.
the case itself?
Yep.
On 6/21 is where this case begins. I received an emailed complaint regarding short-term transient rentals occurring at 530 Camellia Lane from local citizen David Hunter. Within this email, he referenced that this property was additionally listed on a short-term vacation rental site called www.flipkey.com. A search of this website proved this to be correct, that in fact the home was listed for monthly, weekly, and nightly rentals. Additionally, several guests of this property had commented on the stay, referencing the shortened period of time. I drove by 530 Camellia Lane location and found 2 cars on site. I researched the tags of these 2 vehicles and found them both to be rentals. Returning to 530 Camellia Lane in the late afternoon of 6/25 with fellow code enforcement officer Melody Sanderson, I was not able to find anyone at the home. I left my business card in the door. Sometime later, I received a call from a Miss Elizabeth Norton who had found my card. Miss Norton stated she was in from out of state, Minnesota, I believe, and was renting from the Carrolls for 1 week. That afternoon, I prepared and mailed a certified written warning citation without penalty. I received the green card back from my certified mailing, illustrating that the warning citation was received and signed for by Mrs. Tracy Carroll. On 7/2, I drove by and re-inspected and found 2 new cars located at 530 Camellia Lane. Excuse me. Researching these cars, I discovered that they were owned by 2 families sharing a common surname. I was not able to reach either occupant of the home at this time. On 7/3, I verified through the state of Florida's DBPR's www.myflorida.com website that the Carroll family does not possess a license for short-term vacation rentals with the state. On 7/3, again, late this morning, I spoke with Miss Janie Choi on site at 530 Camellia Lane, who stated that she and her family were renting the home until the upcoming Saturday. That afternoon, I issued a citation for $50 penalty to the Carroll family, and I mailed it certified. On 7/6, 3 days later, I received the green card from certified mailing, illustrating a warning citation was received. Citation was received and signed for by Mr. John Carroll. On 7/12, I received a hand-delivered notification from Mr. John Carroll that he did not agree with our interpretation of the land development regulations as they pertain to short-term rentals. A hearing was requested.
Thank you. Anybody have any
How
questions?
many complainants was it? Mr. Hunter, the sole complainant?
It was for this case, yes.
Do you know, is he here?
Is he here?
Yes.
I believe he is, yes.
May I ask him if he or any of his relatives or associates have any proprietary interest in any hotels or motels in the local area?
Well,
I'd like
if I may interrupt,
Yes, you may.
this is the city's case at this time, and they call witnesses.
Okay.
Now, unless the officer or
I'd be
Mr.
very
McGarry want to
interested
call
in
the
that.
witness,
At some point, I'd be very interested in that one.
yeah, I mean, it's up to the city whether or not they want to call him as a witness.
Okay, I'm sorry.
I'm prepared to answer that question. I have no connection to any hotels or
I'm
motels.
sorry, sir. Have you been sworn in?
No.
No. Sorry.
That was my sole
You gonna swear him in,
question.
or? Are we gonna swear him in?
Let me know at what point you may ask questions.
Okay.
Well, you can ask questions of any witnesses testifying, obviously.
But we cannot ask the city staff a question, is that correct?
We need to confine ourselves to the witness testifying as they testify.
Do you have any witnesses?
I do not at this time.
No, it's my turn to take the appeal part. No. All right. For the record, I'm Tim McGarry, the Director of Planning and Development for the City of Vero Beach. In its appeal, the appellants contend that the city's land development regulations have been incorrectly interpreted and applied in their case. In my presentation, I'll demonstrate that the appellant's contention has little merit. To make my case, I will go over specific code provisions that apply to short-term rentals in residential districts and the fundamental legal principle regarding permissible uses in any zoning district. My interpretation and application of land development regulations to the appellant's property is based on the authority granted to the planning director in the city code. Section 6506 of the city code designates the planning director as the official responsible for rendering official interpretations of the land development regulations and for their enforcement. It's under this authority that I prepared an official memorandum to Ms. Tracy Carroll dated June 24, 2011, outlining the city's prohibition against short-term rentals in residential zoning districts. My opinion was concurred in by the current city attorney as witnessed by his initials on that document. I request that a copy of this memorandum be entered in the record. I have it. I will give it to the attorney. If it's available, I'd like to enter this into the record.
Is that in our packet somewhere, Sherry? Okay.
The appellants may try to argue that nowhere in the city's land development regulations is there any mention of short-term rentals or any regulations governing such use of residential property. As I will prove through my testimony, this argument simply doesn't have any substance. The city's zoning regulations have a definition fitting the description of short-term or transit rental use. In Chapter 60, Appendix of the Zoning Code, you'll find the term guest house transit quarters. Now, it should read guest house and transit quarters, but when it was codified, somebody forgot to put the "and" in there. But that's all right. It still is the same. As defined in the code, a guest house and transit quarters is any structure, including converted dwellings, in which less than 10 rooms, with or without meals, are rented or otherwise provided for compensation to transits for their temporary care and lodging. This definition clearly encompasses the characteristic of vacation or short-term rental use. As the records show, the appellants have been renting out their Camellia Lane property to individuals for short periods of time that meets the definition of vacation rental and therefore a guest house and transit quarter use. Although it hasn't come up in this case, but I'm sure it will, the staff acknowledges that the land development regulations are silent on the length of tenancy for transit uses for temporary care and lodging. Webster's Collegiate Dictionary defines transit as not settled, established, or permanent. Temporary is defined as lasting for a time only. Although these terms clearly apply to the appellant's case and similar short-term rentals of property, it doesn't give sufficient guidance for application of regulations. In establishing a clear, bright line on the length of tenancy for transit use, the staff looked to the state of Florida. Florida Statute Section 509.013.4A1 defines a transit public lodging establishment as any unit, group or units, dwelling, building, or group of buildings within a simple complex of buildings which is rented to guests more than 3 times in a calendar year for periods of less than 30 days or 1 calendar month, whichever is less or which is advertised or held out to public as a place regularly rented to guests. The City Planning and Development Department has historically applied the state 30-day limit in its administration of the enforcement of the city code regarding guest house and transit quarter uses, at least since I assumed the planning director in 2006. And in fact, in 2008, we applied in a code enforcement case that was brought to attention of somebody who was doing the same thing and brought compliance. This threshold, is appropriate, as it is the dividing line separating transit from non-transit uses in the state's licensing of public lodging establishments. Any short-term or vacation rental that is a transit public lodging use requires a state license as defined, which means the Carroll should have a state license. The records show that the appellants have been renting out the place by the week and have advertised and held out their property on Camellia Lane to the public for tenancies of much less than 30 days. The appellants have even placed internet ads offering rentals of 1 night, as the code enforcement officer indicated. It would be hard for any reasonable person to claim the use of the subject property by the appellants doesn't meet the code definition of guest house and transit quarters. As I established that the use of the subject property plainly meets the definition of guest house and group quarters, the next step is to review the zoning ordinance to determine if such use is allowed in an R1A zoning district in which the subject property is located. In Chapter 61, Article 1 of the City Code addressing single-family districts, including R1A, you will not find a guest house and transit quarters listed as either a permitted or conditional use. However, if you look in Chapter 62, Article 3, commercial districts, you'll find guest house and transit quarters listed as a permitted use in the C1A, C1, and downtown commercial districts. These zoning districts are precisely where you would expect to find a commercial transit lodging, such as motels, hotels, guest houses, B&Bs, and yes, vacation rentals. Now, the last point I want to make is essential to your understanding of why the Carrolls were cited for use of their property in violation of the city code. It is a general principle of statutory construction regarding zoning codes, and for that matter, other regulations or laws, which has been reaffirmed time and time again in case law and court decisions. This general principle of statutory construction states that unless a use is specifically listed in a zoning district, it is excluded from that district. Therefore, any uses not expressly mentioned in the zoning district are excluded. As a guest house and transit quarters is not a listed use in the R1A district, it is not permitted. To ignore the exclusion principle of statutory construction result in absurd results. Uses could be willy-nilly placed in zoning districts at the whim or discretion of decision makers, which counters the specific intent of zoning to protect the character and maintain the stability of residential areas within the city. The facts I presented clearly demonstrate that the appellant's use of the property for short-term rental use is in clear violation of the city's zoning regulations. A guest house and transit quarters is not a permissible use in R1A or any other city residential zoning districts. The record showed that the appellants have knowingly violated the code despite warnings from my code enforcement officers and me. To my knowledge, they have made no effort to either try to change the code or to seek an appeal of my interpretation through the Planning and Zoning Board, which reviews administrative decisions. Therefore, the staff was asking that their appeal be denied, and it was pointed out what we're looking for. The reason we're looking for an enhanced civil penalty on this is that the civil penalty of $50 is not commensurate with the amount of rental fees that may be produced by this type of unlawful use. To require less of a civil penalty sends the wrong message to both the appellants and other potential violators of the city's restrictions on short-term vacation rentals in residential districts. That concludes my presentation.
Does anyone have any questions of Mr. McGarry?
Mr. McGarry,
Excuse me.
is this interpretation, as you interpreted, is it also interpreted that way, like in Cocoa Beach, Daytona, Clearwater, any of the other competitors for the tourist dollar?
Well, it depends.
I hate to discourage tourists if we were the only ones this strict. That's what I'm thinking.
Well, I'm not here to get at why we have this kind of ordinances, but unless I look at the ordinances, a lot of regulations, communities sometimes regulate these. What the things you should understand is the state has come out with legislation preempt us to do any changes in our codes affecting vacation rentals. Right. So we're relying on codes that were in place prior to June 1st, 2011. All right, so I have to look at those codes, but I mean, other locales.
Not to discourage tourism.
Well, that's what our hotels and motels are for the bed tax. And I think it depends on the community. I came from Monroe County. This is not totally germane in this case. I don't want to get into this, but we had to deal with the same issues down there. And we have a lot of permanent residents here in residential neighborhoods, and stability is important. And that's why you have these kind of rules in there. Communities that are used to more having vacation rentals in there, they get along with them or have regulations that affect those.
And it's a little premature, but let me interject because of your comments, Mr. Richardson. The board's determination in a case like this, where you have a contested citation, is strictly limited. And let me just read from the code. The fact-finding determination of the board for purposes of a contested codes enforcement citation shall be as to whether or not the violation alleged did occur or exists, and if so, whether the person or entity named in the citation is responsible for that violation. That's it. That's all you're supposed to be looking at.
I had a question. You said the first violation was noted in 2011?
No, this was another property they had on Seagrape that they no longer own that property.
So the violation was for the same thing back then?
No, for a similar action, right? A vacation rental of a house, yes.
And they sold the property before we cited them?
Well, they were given a warning citation. After that, they came into compliance. They sold the house and they so they no longer had ownership.
So they knew that this was a violation going into the Camellia House?
In fact, they were certainly aware on the Camellia House because we provided I gave a memorandum was given to Ms. Carroll back June, which I entered in the record here, which specifically addressed the issue of the 30-day prohibition. As I said again, it was also concurred in by our city attorney at the time I made that interpretation, which I've used since I've been here in the city. That's what we used in our 2008 code enforcement action.
And Mr. McGarry, I have a question for you as well. You made mention of warnings that were given before, in this particular case, before the citation was issued. How many warnings were issued? Do you know? Maybe that's a question.
There was one written warning without penalty, and then it went right to a citation with penalty.
Okay.
So there was one on this case.
And the span of time between the citation was approximately
45 days or so.
Okay. Thank you.
How often does this occur with other property owners?
Good question.
Well, that's a very good question. We act on a complaint basis.
Because I haven't seen them come up here. And I've been here.
Well, because we will send warnings out to people that we're aware that may be in violation. The problem with these kind of cases is we have to have facts substantiate they have a violation. So because you advertise, even though you're required to get a special license from the state or a license from the state, it's not necessarily a violation of our code until you actually are caught doing it. So that's why you see the code enforcement officer address the site, check the vehicle tags, interviewed the people, and clearly, and based knew when they were there, talked to them, followed up, and we had clear violation of the ordinance.
You basically probably have to talk to them because it's not against the law to have a rental car on your property, so you'd have to get them to admit.
Right. We get a lot of complaints, but what we try to do, and for instance, with these special rentals, we send out warning letters to people because we do have a list now of the state where special licenses have been given out for vacation rentals. So we will warn people you're in violation of the code. So we try to do that, and you'll see changes in their advertising. But they're still sort of on the radar screen when we have issues that come up or brought to our attention. We don't get a lot of complaints. And in fact, I can tell you that until the recession, there wasn't really an issue here. After that, where people were concerned about their homes, they had to meet. That's when there were more attention brought to that. And it's just is what's happened. But we do follow up on complaints. When we get a complaint, we will follow. We don't willy-nilly go trolling through the internet and all that, but we will send out notices to warning to people so they know that. And once we've done that, we'll keep an eye where we can. But it takes a lot of staff resources to enforce this kind of code. Even if we had regulations in place, it would be strict regulations dealing with vacation rentals rather than just a prohibition.
I have another question. How much does this permit cost for if he had applied for it through the state? What is the cost?
I think it's over $300 or something. I don't know. You could ask the
Mr. McGarry, the license that we're talking about does not circumvent the code or law or ordinance of the city. No, so even if you had that license, it's still...
Well, it's unfortunate the state got the license without checking for the local government. I mean, in our situation, for instance, an alcoholic beverage license, you don't get it unless you get a sign-off from zoning. Well, these are given out, so it's, they don't really look at whether it's violating the local code or not.
And so the license with the state is a moot point for this hearing?
Well, the license for the state, I guess it was the Hobson's choice. You get the license that pretty well puts you on our radar screen because then that means you are or will be violating our ordinance. Mm-hmm. All right. Mm-hmm. And if so it probably some people will probably want to get a license. It won't put you on the radar screen. You'll find there's also. I just want to point out we also go after bed tax. In a lot of the cases, they are paying bed tax, or we'll have people doing homesteading their property, and we'll notify the county clerk's office that is a possible issue. So we do a comprehensive look when we get into these things. We do what we can. I've been told this is an important thing to do. And I will enforce the ordinance the best I can with my staff.
But you only do it with a complaint, correct?
Correct. We don't, as I said, fishing out there.
And people complaining probably think it's going to lower their property, lower the value of the house.
Well, I think it's.
And if they didn't report it,
I think that
as lowered. So.
No, I agree. We're not here to debate any reasons why the code. That's the kind of thing you debate when you want to go and change regulations.
Mr. Chairman, if you don't have any other, the board doesn't have any questions, Mr. Carroll and or his attorney, Mr. Tierney, would be able to ask questions of the witnesses if you have any. This would be the time where you would cross-examine either the officer or Mr. McGarry.
Okay, and then after that, I get to make my presentation?
Yeah.
Yes.
All right.
Well, it's up to Mr. McGarry if he's done with his presentation.
I'm done with mine. Go ahead.
Okay, you done? Okay, Mr. McGarry. I sat on this board for 2 terms, and I really enjoyed it. But I don't believe we've ever had somebody come up from your staff and asked for an enhanced municipal penalty. So can you tell me a little bit about that and the basis of that opinion?
Well, the basis we did for the enhanced, there's a good possibility that the city's going to increase its penalties on certain, and we've gotten direction from the council like to see that. We've got a case here, the type of money involved in these short-term rentals, as you well know, is fairly substantial, and a $50 fine is like a slap on the wrist. So just to increase the fine is why we're doing it in this case. It's different than mowing your grass or these other kind of things. I mean, so if we don't send the correct message out and it's commensurate with what's going on, there's little likelihood that people will continue to violate the law. So this is why we've enhanced the penalty, which $300 is probably chump change when it comes to this property.
But sir, what is the basis? Where in the code does it say that you can do that?
The basis,
well, let me ask. That's a legal question that I would be answering for the board anyway. What the code provides that on a maximum penalty on a code violation is $500. What the code provides is that anyone that does not contest for a first-time violation has basically a reduced penalty of $50. But once a citation is contested, that reduced penalty is waived, and the board can impose a fine up to $500, or a civil penalty up to $500.
Or anywhere in between.
Yeah, yes, anywhere in between.
Right.
And Mr. McGarry, how many citations have been issued by code enforcement for vacation rental property since 2008?
It's probably less than 10. We've done some other verbal warnings. But actual citations, we've had some letters. I don't have that number for you, but it isn't a lot of them. You're correct. I assume that's what you...
Would two be appropriate?
No. Well, at least 4. You're half of them. And you sent... and 1. So it's less than 10. Let's put it that way. It's not a lot.
Well, your staff, through a records search from Mr. Attorney's firm, turned up 2. So...
Okay. Well, you had the answer. I don't have the thing in front of me. We haven't had a lot. As I point out the code board, this issue has not been a major problem in the city until recently. And we do get some complaints, but as I said, it's very difficult to follow up.
So is it your position that short-term rentals hasn't been going on in the city?
Oh, no.
All this time?
No. Short-term rentals are going on in the city, but due to our staff resources, we do it on a complaint basis. Unless I'm giving other marching orders that the council wants us to take on full resources to go after it, I've been acting under that, and that's I've not been told otherwise by the council or my boss. This is basically how the county was doing their enforcement until they changed the regulations.
Yeah, and why did they change the regulations, if you know?
I don't think that, because they had a strong lobby, if you really want my opinion in there, but that's not germane to what we're talking about.
Okay. Mr. Attorney, any questions? Okay.
You want to go ahead and present your case then?
Thank you.
Yeah, make sure you're sworn in. Mr. Carroll, you were sworn in, right?
Yeah, he was.
Yes, okay. My name is John M. Carroll, Jr., C-A-R-R-O-L-L. I'm the owner of 530 Camellia Lane, and I do admit to this alleged violation. I have been involved with this board for, a number of years, and I've found that, I do not agree with Mr. McGarry's interpretation of this quote-unquote ordinance that doesn't really exist on paper, and I'm here to talk about it. And I'm spending good money so we can have a legal opinion presented to the board as well. I've been a resident here for 8.5 years. I first purchased property in Riamar about 10 years ago. Before that time, in 2003, I spent time coming here. I think I've told a few of you that, we did a lot of forensic inspections up in this way after the storm of the century, and that's how I found Vero. And when we were coming up here, my family and I had 2 young daughters then. Now one's in college. We took advantage of Reomar, and we took advantage of it by living in the houses that we were renting. And we would rent them on a weekly basis. We spent Christmas, Thanksgiving, and Labor Day of 2003 in Vero Beach, all in private homes, all vacation rentals. No problem, no issue, no questions asked. I've been in the engineering construction business for 37 years. During that time, I've represented some very high-end clients, Walmart, Wendy's, Walmart, McDonald's, you name it. I used to go all over the state of Texas trying to get those projects approved. The first time you walk into a site, the first time you walk into a city, the planning and zoning director, if it's big enough to have one, would say, no, we don't want you here. Our ordinance is going to stop you from being here. Well, all these years later, we started that business. I think we started in 1981 with Walmart. Now we are 2013. You can't go anywhere without finding a Walmart, pretty much. So the fact of the matter is, the code says what it says. It says no more, no less. Mr. McGarry can say he can interpret the code, but the code has to be readable by an individual. It can't be changed, manipulated, bastardized any other way. About 23 months ago, believe it or not, I was sitting in these very chairs with you guys. All 3 of you anyway. Well, Sherry. And at that time, I put on the agenda to talk about this very issue 23 months ago. It was right after the state statute had changed, where our legislature that we all elect decided that we should not, in the state of Florida, regulate vacation rentals. Now, 23 months later, Mr. McGarry is still dancing out that same tune, the same record over and over and over again, that he can interpret the code.
Excuse me, I object. I object. The code gives me strict authority to do that. I don't know how clear it can be in the code, whether you like it or not.
Mr. McGarry, I didn't interrupt you once.
Well, I'm sorry. I apologize, but go ahead.
Finish.
No, I've already made my statement that you're incorrect. That's what the code says. You heard what I said. Do you know how to? Did you read the code?
Sir,
I can make interpretation of the code. Whether you agree with it or not is not that's important, all right. But don't say I cannot interpret the code. I have the authority. You don't have the authority, do you?
Mr. McGarry, I'm making a presentation here. You already had your turn. So I'd move to strike everything that he just said as out of order and irrelevant, basically.
I would agree.
Mr. McGarry, you will have a chance for rebuttal.
I understand. And I apologize. I'm a rookie at this kind of thing. All right.
Apology accepted. Where was I? I wonder, actually I do, I really wonder, after that meeting where we had that discussion with Mr. McGarry, Mr. Komet said that he didn't represent Mr. McGarry, that he represented the board, if you look at the minutes, because I did last night, that did he actually go back and look and see, well, is his interpretation right? Is his interpretation falling within the guidelines set by the courts in the state of Florida? But today, I'm clear. It's obvious he hasn't done any homework since that time. He's relying on his own belief, and I don't even want to say it for fear of reprisal. In August of 2012, as he mentioned, there was a warning issued on our Sea Grape property. We sent a letter. I hired Rosway Moore et al. They sent a letter on my behalf saying, we want to know what the specifics of the ordinance is that you're citing, and show us how that 30-day rental of property is defined specifically in the code. Now, of course, there is no such definition. He relies on this transient rental statement as limiting the number of days if you go to the Florida state statutes and figure it out. So he went ahead and attached the same memorandum that he just gave to you into the record and sent it back to our attorney. And he said that we couldn't contest a warning. So that was last year. Fast forward, August 14th, 2013. Now we're here again, talking about the same thing, vacation rentals. Now what's transpired since then? A lot of things have changed. There's been court rulings regarding vacation rentals in Fort Lauderdale. Fort Lauderdale's ordinance is similar to this ordinance. It's almost identical. And you guys probably remember that I served on the Code Enforcement Board down there. So I know what that ordinance says. But, why are we really here? Because we're visible in the community. We're out there doing something. We're out there doing good. My family commits to this community. We're doing stuff every day. Now, Mr. Hunter files a complaint against my Camellia Lane house. You know where Mr. Hunter lives? 1 block off the beach, north of Beachland Boulevard. Is that where Camellia Lane is? Do you guys know where Camellia Lane is? 530 Camellia Lane is by the park. It's 2 houses off the park. Now, how does he know? Why would he care what's going on in my house in a completely different area than that? Well, you know why he wants to file against me? Because he can get traction in his complaint against his neighbor. He's using us as a scapegoat to get his neighbor in trouble. That's it. That's the whole thing. He can testify from here to Sunday that he has no remorse or no issues with Carol's. That's BS. He's using us. He's using us. He's using all of us because we're all spending time and money that we could be out there doing good in the community, wasting time here arguing about an ordinance that doesn't exist. Let me introduce my attorney, Tom Turney. He's going to go over the legal aspects of this. Thank you for your time.
Thank you.
Good afternoon. My name is Tom Tierney. I represent the Carrolls. I've provided with each of you and Mr. Comment with a memorandum and some cases and statutes that are relevant to this decision of yours.
You have been sworn in, sir, correct?
Yes, he was.
I have.
Okay. I just wanted for the record.
In fact, if he's only making legal arguments, he doesn't need to be sworn.
That's true, too. But out of an abundance of caution, I was sworn in. We've already talked about the change in the Florida legislature in the 2011 legislative session, where the Florida legislature made a decision that it was not going to allow local cities and counties to regulate vacation rentals in the state of Florida anymore. And that's why the state legislature passed a law that said that no county or city ordinances interpreting or regulating vacation rentals may be passed after June 1st, 2011. It didn't affect ordinances that were already in place, but any new ordinances were precluded by that statute. I provided you a copy. It's 509.032 of the Florida statutes. But yes,
was our ordinance in place before that time?
The ones that Mr. McGarry and the city staff are arguing preclude short-term rentals were in place before that.
Right.
Yes.
Okay.
I think you ought to orient yourself to the concept that people have private property rights. Homeowners have private property rights. The law allows cities and counties to restrict those private property rights, but when they do so, all questions or when you interpret those statutes, they are to be interpreted broadly in favor of the homeowner. And I cited to you a case, one of the 3 cases I provided to you, which is called Ocean's Edge Development Corporation versus the Town of Juneau Beach, and that was a Court of Appeals decision for the same District Court of Appeals that covers Vero Beach from 1983, where a Court of Appeals struck down a city ordinance from the Town of Juneau Beach where they were trying to restrict a homeowner's use of his or her property. I also more particularly want to focus you on 2 things. One is the statutes or the codes, the city codes that were cited that my clients allegedly violated. They are Section 60.11, which is a generic section, and 61.02, which deals with permitted uses in residential districts. In no place in those codes does it preclude rentals for less than 30 days. It doesn't say that anywhere in the city codes. Mr. McGarry would like it to say that, apparently, and he has admitted that the city codes are vague with respect to that, so he has decided to interpret it by reference to Section 509 or Chapter 509 of the Florida statutes, and claims under 65.06 that he has that power. Unfortunately for Mr. McGarry, however, there are 2 other cases, more recent cases, that I provided copies to you. One is the Milo case versus the City of Venice, and the other one is the Dal Bianco case versus the City of Fort Lauderdale. Those are circuit court cases, one from 2008 and one from 2012, in which circuit court judges struck down interpretations of local city codes, just like this one, that were where the city was trying to preclude short-term rentals. The basics for Mr. McGarry's interpretation, and it is only Mr. McGarry's interpretation of the city code, is in Section 61.01 of the City Code, subsection B, where it says, "It is the express purpose of this section to exclude from this district," meaning residential district, "all buildings or other structures and uses having commercial characteristics, whether operated for profit or otherwise." So what does that mean? What is a structure or building having commercial characteristics? Mr. McGarry has determined that renting a residence for less than 30 days has a commercial characteristic. I submit to you, how is that different from renting for 30 days or renting for 60 days? How does it become commercial by making it for by renting for less than 30 days? There's nothing in the city code that would make that distinguishment between the plus or minus 30 days, that magic number of 30 days that Mr. McGarry has determined makes all the difference between commercial and not commercial. Mr. McGarry cites also to a definition in Appendix A to Section 60, which I provided you with a copy of, that defines guest house transient quarters. It says, "Any structure including converted dwellings in which less than 10 rooms, with or without meals, are rented or otherwise provided for compensation to transients for their temporary care and lodging." Less than 10 rooms. What does that mean? What's a room? There's no definition of room in the appendix. Does that mean bedrooms? Does that mean rooms? According to the code enforcement folks, the Camellia Lane house in question actually has 5 bedrooms and 6 bathrooms, so it has 11 rooms. So under that definition, it may not even apply. But more importantly, there's no definition in the code anywhere of what is a transient or what is temporary. What does that mean? Does it mean, what's a transient? Is that a person who stays in a hotel room for a night? Is it a family that stays in a vacation rental for a week? Is it a family that stays in a vacation rental for a month or for a season? The Dodgers used to come down and stay in people's homes for spring training for 6 or 8 weeks. Does that make them transient? That wasn't their permanent residence. So where do you draw the line? Mr. McGarry has tried to draw the line by reference to Section 509.013 of the Florida statutes. Unfortunately for him, when other cities have tried to do the same thing, the courts have told them they can't. And those are the 2 cases I cited to you. The Milo v. City of Venice Beach case rejected the city's position that required that and said that a similar ordinance must contain a specific duration of tenancy in classifying in the commercial context, in classifying whether a rental was commercial or not commercial versus residential. That case, Milo v. City of Vero Beach or City of Venice, the court said you can't just decide without any reference to the code that commercial is more than or is rentals for less than 30 days and residential is rentals for more than 30 days. That's the City of Venice's position in that case, and the 12th Circuit Court struck it down. There's another case, and that case said, and I'll quote from it, "It is not possible for a property owner to anticipate that, for the purposes of the city code, it would be necessary to look under Chapter 509 of the Florida statutes. Therefore, it was clearly erroneous for the city to graft definitions onto the city code from Chapter 509 of the Florida statutes." There was a more recent case in 2012 in the city of Fort Lauderdale called Dal Bianco versus the city of Fort Lauderdale. In that case, the city tried to restrict a homeowner from renting their house for less than 30 days and used the same language, and that case relied on both the Milo v. City of Venice case and the Ocean's Edge case that I talked about. The Ocean's Edge case said property owners are entitled to rely upon the clear and unequivocal language of municipal ordinances. It also said, and that's the 4th District case. In this case, Mr. McGarry would agree with me that the language of the ordinance is neither clear nor unequivocal. So what's happening here is that the city staff is effectively amending the city code as the staff would like the code to read, not as it is drafted. If the city wants to prohibit short-term rentals, in effect, Mr. McGarry is operating in a legislative capacity. He's coming in without public input, without a vote of elected officials, and saying, this is how we're going to interpret this particular ordinance. But that's the cases, Ocean's Edge in particular, says you can't do it that way. If you want to prohibit short-term rentals, you have to change the current city code to prohibit short-term rentals. Define what transient means. Define what temporary means, and go through the process. You have city council. You go through that. You have public input. You have an open meeting, and then the city council votes, and they're subject to the election every 2 years by the people of the city of Vero Beach. And that's not what's happening here. So our position, as Mr. Carroll said, isn't that he didn't rent for less than 30 days, because he did. His position is a legal position that the city code does not prohibit short-term rentals as it is currently written. Thanks.
Staff, would you like to cross-examine any of the...
Right. Well, the attorney.
Well, I wasn't testifying, but...
Oh, okay. Well, I'm sorry. I'm being a rookie at this. So
I'm a rookie. Mr. Carroll's coming. He'll address
Yeah,
it.
bring Mr. Carroll over. I'm sorry. Sorry. Well, one of the situations Mr. Carroll said that our case is similar to Fort Lauderdale. Mr. Carroll, I've read the Fort Lauderdale case. We're not similar. We do have a definition of guest house and transit quarters.
Let me interrupt. If you're going to put on more testimony, or argument to the board, or do you have questions for Mr. Carroll? This is a point where you can cross-examine.
Well, I liked him to explain why.
Okay, I'm
it's
sorry.
Similar. That's what I'm trying
Excuse
to find
the
out.
interruption. Sorry.
No, that's okay. Just keep me in the straight and narrow.
So the question is, why is it similar?
Yes.
Is that your question? Why is the Fort Lauderdale case similar? Tom will have to answer that. I'm an engineer, guys.
Well, I'll tell you. I'll read from the case. In that case, which is the you asked for the Fort Lauderdale case. I'm sorry.
Let me ask a question right now. I've not been given any of these cases, so I'm operating in the dark, except for the Fort Lauderdale case. So, but then again, I
think it was part of our agenda, which was part of the public record. Wasn't it?
I think he's talking about what we just received today.
And Swan documentation.
Okay.
But that's all right. I asked you in the Fort Lauderdale case.
The only thing I have about that says that the notice of violation in that case, according to the case, said the owner of this single-family home in this residential district is operating it as a commercial business involving short-term rentals. This is a prohibited land use in this district, per section 47-5.11.
And you would agree if you looked into the clearly, they were using their single-family definition. We do have the guest house and transit quarters is a definition they didn't have, so they had a weak case to begin with.
I don't know whether or not they did.
But
have that
I've looked over it, and that is. And let me ask you: you also
but you also said that in order to interpret the definition of guest house transient quarters, you had to look to Chapter 509 of the Florida statute.
I understand. We're tenancy. That's always been an issue on that. The staff doesn't disagree that it is not in the ordinance. I do want to point out to the board that you did make a statement that we could change laws. We can't change laws. You know that. That the state has preempted us, so we have what we have. There is no way we can change the laws to make this more clear.
I'm not giving you an opinion on that.
No, but that's what the condition is in there, and it's pretty well stated in there. Okay. I beg to differ the way you took the guest house and transit quarters. It says structure. The included in the rooms is not, it says including where you have 10 rooms or less. So that basically is set in there to define it from hotels, motels, but it says any structure. So I think this residence clearly is any structure. It doesn't matter how many rooms in it. I don't think that's significant an item in this case. And I think basically what you're arguing...
Is he asking, Mr. Comment, is he asking a question?
Yes.
If you have questions for him, otherwise, if you just want to put on your rebuttal with Mr. Tierney is done.
I apologize. I'm trying to get him to agree with me, but that's all right. I can do that as in my closing.
Mr. Tierney or Mr. Carroll, if they don't have anything further, you would go to the city's rebuttal, if any.
Unless there's questions from the board?
I have a question.
Yeah, certainly.
Yes. Your client was aware of this law back in 2011 where, with the rentals, that a permit was needed and then a bed tax would be paid if, in fact, this was the case that you could rent on a nightly basis, weekly basis, monthly basis. Is that correct?
I don't know. You'll have to ask my client.
Okay.
We've never rented nightly, so I don't know why people keep saying that. We always rent on a week basis, and there has been sales tax paid. We were not aware that the vacation rental was required to have a license. We just found out about that a couple of weeks ago when somebody from the state showed up at our Vero Beach office and handed my assistant an application and said, please mail it in within 60 days, and that has been sent in, and that's where we stand.
Do you have any type of license to do business as anything there concerning that?
At our Vero Beach office?
Yeah, for the rentals.
No, the rentals.
At Camellia Lane? No, we don't have a license.
Aren't you required to?
Like I said, we were just informed that the state actually is licensing vacation rentals now. And if you apply for a vacation rental license, there's no duration. It doesn't say 1 day, 6 days, 365 days. It's just vacation rentals. And it's a fee based on the county that you're in. Like Indian River County is like $310. Other counties are more, and some counties are less.
You're paying taxes on an income, but you don't have a license to do that business.
Well, that's not what he's cited for.
I know. Oh, I'm sorry. That's none of my business.
How's that?
So the bed tax that you're paying was effective as of this Camellia house rather than what it was in 2011? Because I think the bed tax has been in...
Anytime we've rented property on a weekly, monthly basis, we've paid a bed tax, no matter where it was.
Everybody clear?
Well, I think I have a question for Mr. Carroll. You knew that there was a contention with the rentals, 30 days or less with the city. You've come across this before. And maybe it wasn't possible, so maybe this question isn't a good question. But was not the time to, if it was even possible, to try and resolve this before a citation was issued for the Camellia home and then an appeal made for that citation? Or maybe it was assumed that it would just go away. Maybe you couldn't do it.
Maybe you missed some of my testimony. The initial warning we got was on secret. After that warning, I was on the board, your board, and we, as a board, discussed it with Mr. McGarry. And I tried to get a motion made at that meeting to say that Mr. McGarry could not interpret the code as he indicated. And Mr. Komet, acting as the attorney for the board, said we could not do that because that's part of planning and zoning. And that's in the minutes. September 9th, 2011. I looked at it last night. So last year, when it became another issue, they said we couldn't appeal a warning. So that was our second issue. We couldn't do anything with it. So now we're here, and I said, go ahead, slap that fine on me, because I want to get this over with.
Thank you.
Any other questions? Does anybody from the public have anything to say?
No, we can't do that in this type meeting. No, this is quasi-judicial.
Following my cheat sheet.
No, I'm sorry. That shouldn't be on your cheat sheet. No, only called witnesses can testify.
Okay. That brings us closing arguments. Mr. Carroll, do you have
I don't know if Mr. McGarry had any rebuttal testimony to put on.
Yeah, I would like to.
Or is it just argument?
He's last, isn't he?
Well, my testimony would be a rebuttal, I guess. Yes. I want to go over a couple items that were brought up by the attorney. First, the definition of guest house and transit quarters. If you carefully read it, they talked about 10 rooms of that. That's immaterial to this. If you read the actual definition, it says any structure, and then it says including converted dwellings in which less than 10 rooms. So any structure meets that definition that is rented for compensation, transit, and temporary care and lodging. Just want to point that out. I think it's very clear in the ordinance that it meets that. The other issue that came up had to do with the amount of time. Clearly, we acknowledge the 30 days is not in there. I've not had an opportunity to review these court cases, so I can't I think that's something for the matter of courts. I think we've been very clear on how we define this. It's certainly been made public. It isn't like it was a surprise, particularly in this case. If there was a real issue there, to change the codes. They had plenty of opportunity to do that on this situation. The other thing, let me point out, if you're correct when you brought up the thing, if they are operating a vacation rental, a business tax is supposed to have been paid. And our office has never been contacted about a business tax, but then again, we would have had a catch-22 for them, so we've never made that a big point. But basically, I think that whole issue about, believe it meets that it is not a listed use in there. I think it clearly meets that. So the real issue revolves around tenancy, and I think clearly a reasonable person say the 30 days is plenty. It's not in the code. I understand that, but I think that's something for the courts to resolve rather than for us at this point in time, because I think we've been very clear on it. It's certainly a little different than I don't know the other cases. So we stand on our presentation.
Thank you.
Mr. Chairman, if I may. Mr. McGarry, you said you were familiar with the Fort Lauderdale case?
Sort of familiar, yes.
Okay.
I'm not going to.
You seemed to intimate earlier that perhaps the City of Vero Beach's code differs from Fort Lauderdale. Could you explain that a little bit?
Right.
For
The
us,
Fort
maybe?
Lauderdale, there were two issues, and I'm just paraphrasing, revolved around residential use, and they're trying to say that on the definition of single family, it didn't define what kind of use is in that house. Now, we don't have that situation because we don't get into defining what a single family, but we do have a guest house court which clearly fits that definition. So it does limit if those are only allowed in commercial districts. Clearly, it was not intended to be. It didn't say any type of commercial. It said any structure, and that clearly meets the definition there. The other issue had to do with the time frame. I don't think they even referred to the statute, the Florida statutes on it. But then again, they had some other cases. So we do have a different situation in the Fort Lauderdale case, in my opinion, based on my layman's look at it.
Do you think it should be in the city code?
As I pointed out, I wish the code had this specific language in here. But the state of Florida, in their infinite wisdom, has gone ahead and preempted local governments to deal with this.
So the only change we can make to the code would be to eliminate it altogether. Is that correct?
Well, I don't know. Maybe for a point of clarification, on your interpretation of the code, though, what is the use that you're talking about? Transient rentals?
Transit use. The guest.
No, I mean, what's the actual?
Guest house and transit quarters.
Okay, so transient you could look up in the dictionary.
And I did give definition in the dictionary.
And what is that?
But it isn't.
What's that definition? Do you know what it is?
In the dictionary, transit is not settled, established, or permanent. Temporary is defined as lasting for a time only. I mean, clearly.
So is this 30 days, is that really just something you use as a trigger mechanism to go enforce?
Basically, that I needed to set some sort of bright line so property owners could be aware of what was expected of them, what was in the code. The 30-day was a very good demarcation because under that you would need a state license. And the state considers that a transit residential type use.
That's all I had, Mr. Chairman.
You made a statement earlier about we have to follow a certain thing.
Well, I still have it up. It's basically and of course we're not done because you can have some more argument. But again, the fact-finding determination for the board has to do with whether or not the violation as alleged on the code enforcement citation did in fact occur or still exists. And if so, whether the person or persons cited are the ones responsible for that violation. That's your fact-finding determination.
So we have to go by his interpretation because it's his right to interpret it.
Well, he does interpret under the code. You, of course, have the final say in a case like this. You're the code board. Based on the argument of what those interpretations should be.
Yeah. I kind of think this actually should go before the city council instead of us, but we're here.
Well, if it was legislative and someone had gone to the council or even first to the Planning and Zoning Board to suggest that there should be a code change, whether it be for clarification or for a repeal or for an added addition of uses to a single-family residential district, whatever it might be, yes, it ultimately would go to the city council, but that would be legislative. Here we're in a quasi-judicial situation where people have been cited and they're contesting the citation as to basically the interpretation of how the code is interpreted and applied. So that's why you get to have fun with it. And you would want to let Mr. Tierney or Mr. Carroll, of course, make any closing statements, and Mr. McGarry also.
Mr. Carroll, Mr. Tierney.
Having served on this board a number of years, I know how hard it is to sit in those chairs and go against our friends and neighbors here at this table. You know, we rarely did it, but when we did it, we had a reason to do it. I wouldn't be here today if I didn't firmly believe that Mr. Turney's research is spot on, and it's spot on the way anybody that would really admit it sitting in this audience would never know what his interpretation would be. And the code should be clear, just like a speed limit should be clear. If there's 400 people driving down this road and Mr. Hunter says, John Carroll's speeding. Oh, is he? Well, let me call up Mr. McGarry and find out if he can speed here, because I want to know. That's what we're talking about here, guys. It's as simple as that. Either have an ordinance or don't have an ordinance. You guys aren't here to decide whether vacation rentals are right for Vero Beach or not. The state has already made that decision. What we're here to talk about is, did we violate the code as it's written? As it's written. Thank you.
The only final statement I'd like to make is to remind you of the definitions of transient and temporary that Mr. McGarry gave you. There's nothing in there. Those definitions apply to residences or tenancies of 30 days or more just as much as they apply to tenancies of 30 days or less. There's no differentiation in those dictionary definitions that say transient is someone who stays in a residence for less than 30 days. It talks about temporary. People come down and visit and stay in Vero Beach for 60 days during season, but that's a temporary residence. They keep their homestead up north somewhere. So to say that the dictionary definition supports Mr. McGarry's position is inaccurate, I think. And you all heard the definitions. I think you would agree with me. Thanks.
Thank you.
We're allowed to hear from the man that made the complaint. We're allowed to hear from the person that made the complaint?
Not unless he's called as a witness.
Okay.
By either side could call in.
Nobody has. We're past that.
I'd like to hear.
He's just catching up.
Oh, okay.
Mr. McGarry?
Yes.
Anything else to say?
Well, all I want to say is that any reasonable person can say this is temporary use of the property. To make comments that, there's no defined, that's of course. Yeah, you could make that thing maybe 10 years is only temporary. But clearly the use of this property is being used on a temporary basis. In the dictionary, the 30 days, we're dealing with a few days here. It's a temporary use of the property. Yeah, the code doesn't have this explicit language in there. That's why we've applied the 30-day thing. I think I still believe that from a reasonable person would say this is a transit use of the property, and to be arguing that otherwise is I don't think meets what the intent is of these restrictions, and why guest house and transit quarters are placed in commercial areas and not in residential districts. Thank you.
Any discussion?
There's a young lady back there. She can't be called up.
She cannot. Well, I would make a motion that the city code is unfortunately very vague on this issue, and therefore there was no violation.
I'll second that motion. I'll second that motion.
No.
Moved and seconded. All in favor? Aye.
Nay.
Aye. Maybe you should call the roll.
That'd probably be best.
Michelle?
No.
Mr. Howell?
No.
Mr. Richardson?
Yes, as to John's motion.
Mr. Hargett?
Yes.
Mr. Noonan?
Yes.
It's 3-2. It passes 3-2.
Motion carries.
Excuse me, don't we need 4 votes?
No.
On this
No,
appeal?
it's only a majority of those voting. At least 4 have to vote, and we had 5 voting.
Thanks, everyone, for coming. You're welcome to stick around. We have a lot of exciting things still yet to come. He wasn't cited for not having a license, ma'am. Well, talk to these people sitting right in front of us.
Five minutes, clear the room before we start. Mr. Chair, may we take a 5-minute recess and allow the room to clear before we proceed?
Please.
Good idea.
We can all have a recess. Yeah. I'll call a 10-minute recess. There'll probably be a line at the